Welcome to the Deep Dive. Today we're digging into, well, a single legal case, but one that acted like a constitutional hinge. It fundamentally redefined the relationship between the Canadian state and the individual body.
It really did. When you look at legal history, these moments of huge change are pretty rare.
Right, but when they hit, the ripples just transform society.
Exactly. In this case, R.V. Morgentaler from 1988, it's definitely one of those moments.
So we're here to give you, the listener, the most detailed shortcut we can. Not just the drama behind it, which is significant,
Absolutely.
but why its constitutional reasoning is still such a powerful legal pillar today.
It really is one for the history books. I mean, the sources we looked at put Morgentaler right up there in that rarefied air of landmark judgments.
Decisions that didn't just, interpret the law, but fundamentally reshaped things.
Totally. Think about the context, the other cases mentioned in the material. You've got Marbury v. Madison, 1803, in the U.S.
Establishing judicial review.
Huge! Cementing the court as a co-equal branch. Or Brown v. Board of Education, 1954.
The moral force of that one.
Yeah.
Starting the legal end of school segregation.
Yeah, it's formative.
And even outside constitutional law, moving into torts, there's Donahue v. Stevenson.
The snail in the ginger beer bottle, 1932.
Seems simple, but it established the modern idea of duty of care. Still affects almost every negligence case everywhere.
So for R.V. Morgentaler to be in that kind of company, it tells you this is way more than just a case about a specific medical procedure.
It's about establishing a really profound constitutional right.
Absolutely. It's about the limits of state power, fundamentally. So our mission today is to really unpack the history, the legal mechanics.
Get into the weeds.
Exactly. Explore how the sheer, just relentless defiance of one physician, Dr. Henry Morgentaler,
Incredible story.
how his fight forced this constitutional showdown, and how that resulted in a groundbreaking guarantee of freedom and security of the person for Canadian women.
A principle now locked in at the highest level of law.
It's a story of personal conviction pushing hard against, well, legal inertia.
Okay, Section 1. To really get the scale of the 1988 shift, we have to understand what things were like before, the legal status quo.
Right. It was oppressive.
Before 1988, abortion was broadly illegal, explicitly so, under Canada's Criminal Code, Section 251.
And this wasn't just, medical regulation. This was serious crime. It carried the threat of criminal sanctions, jail time.
That's the essential starting point for you, the listener. While it wasn't an absolute ban, the exceptions in Section 251 were, well, they were incredibly narrow.
And complex, administratively, a real burden. They made legal access virtually impossible for huge numbers of women.
The abortion was only legally allowed if it met this one. Very strict requirement.
Yeah, a woman had to get the procedure certified, necessary to protect her health. And that decision couldn't just be made by her doctor.
No, it had to be made by a special committee, a therapeutic abortion committee, or TAC.
Set up within an accredited or approved hospital.
Let's just pause on this committee structure for a second, because this is really where the law became so unjust in how it was applied.
Absolutely critical.
It wasn't enough to have your own family doctor or your gynecologist confirm the medical need.
Nope. You needed a panel, 3 doctors, a committee, to actually convene, review your specific case, and then sign off on it. Approve the procedure.
And the sources just lay bare the reality of this structure. It was riddled with problems, arbitrariness, geographic inequality.
Hospitals weren't even legally required to set up these committees.
Really?
Yeah.
So they could just opt out?
Yeah. If a hospital board, maybe for moral reasons or religious ones, just refused to form a TAC,
Wow.
tough luck for the women in that whole area.
Wow.
Yeah.
So denied legal access entirely, no matter their medical situation.
Exactly. And this led to huge geographic unfairness. Access was basically concentrated in the big city teaching hospitals,
Leaving women in rural areas or smaller towns.
facing agonizing choices, often impossible ones,
And even where these committees did exist, they added bureaucracy, delay.
which is a massive problem in this context. Delay is dangerous.
The sources show the process. Getting the 3 signatures, getting the committee to meet, waiting for the review, then scheduling. It often took weeks.
Sometimes months. And for a medical procedure where safety drops rapidly as the pregnancy progresses, that bureaucratic delay itself was a threat to health.
A direct threat.
Precisely. And the criteria the committees used, subjective. often applied completely differently from one hospital to the next,
So one committee might approve based on psychological distress.
while another might demand proof of imminent physical danger, life or death, basically.
It's chaos.
And when the legal routes are blocked or delayed or just arbitrarily denied like that, women are often left with only desperate choices.
The sources confirm it. This period saw the continuation, that frightening reality of
Yeah.
unsafe, illegal procedures.
The whole back alley context, with devastating consequences, sometimes fatal.
That's the backdrop, the stage for the conflict.
Yeah. So into this landscape steps our central figure, Dr. Henry Morgentaler, a physician in Montreal, also a Holocaust survivor, which surely shaped his perspective on state power and individual rights.
He watched this system just fail his patients over and over, and his core belief, the thing that fueled him for decades,
Was that women had a fundamental right, non-negotiable, to control their own bodies?
and that the existing law, Section 251, was nothing less than state infringement on that right.
Morgentaler knew that trying to change the law through parliament, through normal politics, it was probably futile.
So his method was audacious.
Pure, direct civil disobedience, deliberately designed to provoke a legal fight, a confrontation.
So back in the late 60s, early 70s, he started opening private clinics, in Montreal first.
And crucially, performing abortions without seeking or getting approval from those therapeutic abortion committees.
He was deliberately, publicly, repeatedly breaking the law, throwing down the gauntlet.
And the state responded exactly as you'd expect. This wasn't some quiet disagreement.
No, it was a relentless cycle. Defiance, then consequences.
He was arrested again and again, multiple trials, and the sources mention he was actually jailed for a time.
Even though juries in his early Montreal trials kept acquitting him, which caused its own uproar.
That's a key point from the 70s. The Crown actually used legal maneuvers to overturn those jury acquittals.
Showing how determined the government was to enforce Section 251 no matter what.
But Morgentaler's own determination, it was just unbreakable. Every single time the government shut down his clinics, seized his equipment, prosecuted him.
He'd just come back, go to the court of public opinion, reopen his doors. For him, this was clearly a decades-long fight driven by deep conscience. He was forcing the legal system, either validate this law or change it fundamentally. And that sustained high-stakes opposition, that refusal to back down, is what eventually pushed the whole thing to the Supreme Court.
Right. Section 2, the courtroom confrontation. His repeated defiance through the late 70s into the 80s, with major showdowns happening in Ontario and Quebec, too. It meant the issue just got too big, too national. It couldn't be ignored or just handled province by province anymore.
Morgentaler's legal team basically engineered a situation. They forced the issue. It demanded a final, definitive constitutional ruling from the highest court.
And the national tension then was, you could feel it. This was way more than just a criminal case against one doctor.
It was a showdown, right? Personal freedom, bodily integrity on one side.
Versus the established authority of Parliament to define criminal morality, and crucially, the protection of unborn life, which the state claimed as its main objective.
So the court had to weigh these competing, really fundamental values, and it had to do it under the new framework of the Charter.
The Canadian Charter of Rights and Freedoms, brought in 1982. That changed everything.
Let's dive into the core legal strategy here, because the Charter became the ultimate weapon for Morgentaler's side.
His lawyers argued that Section 251 of the Criminal Code violated Section 7 of the Charter.
Not just bad policy, but unconstitutional.
Exactly. And Section 7, well, it's often seen as one of the most powerful parts of the Charter.
It guarantees everyone the right to life, liberty, and security of the person.
And crucially, the right not to be deprived of those things except in accordance with the principles of fundamental justice. Okay, so Morgentaler's team zeroed in on that phrase, security of the person, and principles of fundamental justice. That was the battleground.
But hang on. If the government's goal was genuinely about protecting unborn life, which is arguably a valid legislative objective, shouldn't the court have just deferred to Parliament?
That's the million-dollar question the court faced.
Why did the process, the mechanism of the therapeutic committee, end up dooming the law?
That's exactly it. The legal win wasn't based on proving the government had no interest in the fetus. It was about proving that the method Parliament chose
This Section 251 committee system
was so deeply flawed that it violated those principles of fundamental justice. Specifically, the court found the system failed because it was vague, arbitrary, and overbroad.
Okay, can we unpack those three? Vague, arbitrary, overbroad. Because that's the technical bit, the real deep dive detail.
Sure. Arbitrariness meant the committee system often granted or denied access based on things that shouldn't have mattered. Subjective whims, irrelevant factors.
Leading to totally inconsistent results across the country.
Right. Vagueness referred to the legal standard itself, health. What did protecting the woman's health actually mean? The law didn't define it.
So committees applied it inconsistently. A mess.
And overbreadth meant the law basically went too far. It restricted access more than was necessary to achieve its stated goal.
For instance, restricting access even really early in a pregnancy, where the state's interest might be seen as less compelling.
Exactly. It swept too broadly. So the argument became forcing a woman to navigate this arbitrary, vague, often impossible process, where delays increased her physical risk and bureaucratic denials hit her psychological integrity.
Was a direct and profound violation of her security of the person.
It effectively treated her body not as her own, but as, what, the property of the state or the committee. And that's a really holistic view of security of the person. It recognized both the physical and the psychological damage the law caused.
The state was using the threat of criminal law to force a woman to accept procedures, timelines that endangered her health.
The law demanded she comply, but it gave no guarantee of access, no guarantee of timely treatment. And that deprivation of security wasn't consistent with fundamental justice.
Okay, but let's be fair. We need to look impartially at the government's counterargument. It was robust, right?
Absolutely. Their main position, as noted, was the constitutional protection of unborn life and the need for Parliament, not the courts, to define criminal morality.
They argued Section 251 was a legitimate exercise of Parliament's power under the Criminal Code section of the Constitution.
And they argued that the tax structure, the committee system, was actually Parliament's attempt to strike a balance.
A constitutional balance.
Yeah, between protecting the fetus and protecting the mother's health needs. They maintained that this balance, even if imperfect, was properly struck by elected MPs.
And judges should defer to that legislative choice.
Right. Deference to Parliament.
And they also pushed back hard on Morgentaler himself, didn't they?
Hmm.
Arguing doctors can't just decide which laws to follow based on conscience.
That was a big part of it. If every citizen could ignore laws they disagreed with, the whole legal structure would collapse.
So for the government, this wasn't just about abortion. It was about the rule of law, constitutional checks and balances.
And the primary role of the elected legislature in defining what is or isn't criminal conduct.
They were essentially saying the system, flaws and all, was the only way to recognize the value of the fetus while still providing a legal escape hatch for the mother.
And that the flaws, while real, didn't reach that very high constitutional threshold of a violation of fundamental justice. It was a powerful argument for parliamentary supremacy.
Okay, Section 3. The judgment itself. 1988. The showdown finally reaches its climax.
Decades of struggle by Morgentaler, years of complex legal fights. The Supreme Court delivers its verdict.
And the decision was 5-2 to strike down Section 251. It was declared unconstitutional.
The immediate effect. The criminal ban just vanished, ceased to exist.
Now, it's important, you said, that while the court agreed on striking down the law, they were fractured on the reasons why.
Highly fractured. Different justices had different paths to the same outcome, but the strongest, most influential reasoning focused on that Section 7 violation we discussed.
And we have to look closely at the words of Chief Justice Brian Dixon.
His reasoning really formed the core. This is where the constitutional philosophy shines through. Dixon, writing for the majority on the Section 7 point, delivered this foundational quote. Let me read it. Please do. It's crucial.
Forcing a woman by threat of criminal sanction to carry a fetus to term unless she meets certain criteria unrelated to her own priorities and aspirations is a profound interference with her body and her security of the person.
That quote is just revolutionary in Canadian law because it takes security of the person beyond just, say, protection from physical assault.
It connects it to the right to make fundamental life decisions. Exactly. Let's break down those two key parts. First, profound interference with her body. That's the direct link. Bodily autonomy.
Dixon established that the state using criminal law to dictate what happens inside a woman's body, especially when the supposed safeguards are flawed, is a constitutional trespass.
The state can't just commandeer your physical self under threat of jail.
Right.
And then the second part, the phrase that really elevates it beyond just fixing a bad process, unrelated to her own priorities and aspirations. This goes right to the heart of self-determination, doesn't it?
Precisely. This is the direct hit on the committee system's failure. Dixon saw that the text essentially forced a woman to subordinate her entire life, education, career, family, mental health, to this arbitrary panel of doctors.
The law failed because its criteria weren't about the woman's reality. They were about the subjective, inconsistent views of strangers.
And Dixon recognized the woman as a full moral agent, capable of making decisions central to her own life. That elevates her right to control her life circumstances into a constitutionally protected principle.
We also have to mention Justice Bertha Wilson's concurring opinion, right? It was groundbreaking, too.
Absolutely. While Dixon focused heavily on the procedural unfairness, how the law violated fundamental justice from the lawyer, Justice Wilson went further.
She argued the law violated Section 7 rights because it deprived women of liberty in a more fundamental sense.
Yes, the liberty to make essential decisions for herself. Wilson argued that the right to decide about your own body is core to human dignity and freedom.
She said the decision whether or not to terminate a pregnancy is one of the most important, most intimate decisions a woman can make.
And therefore, it must be protected by the Charter. So while Dixon's procedural path was maybe the binding legal route for the majority,
Wilson's focus on the substantive right to autonomy offered this powerful, more expansive constitutional vision. It was incredibly forward-looking.
it really was. Okay, essential point for a deep dive. Section 1 of the Charter, the Reasonable Limits Clause. Ah, yes. Even if a law violates a right, like Section 7, the government can try to save it under Section 1.
If they can prove it's a reasonable limit, demonstrably justified in a free and democratic society. The Oakes test.
Right. Did the government try to save Section 251 using Section 1?
They did, and this is where the Morgentaler judgment really slammed the door shut on the old law. The government argued the restriction was justified because of its objective, protecting the fetus. Okay, a potentially valid objective.
The court generally agreed the objective could be considered pressing and substantial, the first step of the Oakes test, but then they looked at the means used.
The Therapeutic Abortion Committee structure. And it failed the next crucial step, the minimal impairment test, meaning the law was just too intrusive. It went further than necessary.
Exactly. The means Parliament chose were not rationally connected to the objective in a fair way, and they impaired the right to security of the person far, far more than necessary.
The procedure was too complex, too arbitrary, led to dangerous delays.
It just couldn't be considered a minimally impairing way to regulate the issue. So the finding was crystal clear.
Access to abortion wasn't some privilege granted by a hospital committee.
It was a matter of constitutional freedom, and the law failed every single constitutional test thrown at it. Wow. Okay, Section 4, Impact and Legacy. The immediate result was, well, unprecedented in Canada, legally speaking. Right. The law was struck down for constitutional reasons, so it was instantly void. Gone.
Canada suddenly had no federal criminal law governing abortion at all.
A complete vacuum in the criminal code on this issue.
And the political reality then kicked in. Parliament could have tried to draft a new law, one that maybe respected the Charter.
Perhaps regulating later-term abortions or getting rid of the committee system but keeping some rules. That was an option.
But the sources really stress this crucial, lasting political fact. The thing that has defined Canada's situation ever since.
Parliament never successfully replaced the law.
There was a major attempt, though, right? We need to talk about Bill C-43.
Oh, absolutely. That wasn't a quiet failure. That was pure political theater.
High drama.
This was 1990. The government at the time introduced Bill C-43. It was their attempt to recriminalize abortion, but with a different framework.
Trying to make it charter-proof this time.
That was the idea. It would allow abortions unless a doctor believed continuing the pregnancy would not threaten the woman's physical, psychological, or emotional health. A sort of streamlined medical necessity test.
Hoping that would meet the Section 7 requirements laid out in Morgentaler. So what happened to Bill C-43?
It actually passed the House of Commons, but it died in the Senate in 1991.
The Senate. The chamber of sober second thought.
That's the one. They were deeply divided. And the final vote in the Senate ended in this incredibly dramatic 43-43 tie.
The perfect tie. Wow.
So the bill was only defeated when the Speaker of the Senate, the presiding officer, cast the deciding vote against the legislation.
One vote. A 43-43 tie decided by the Speaker. That single moment really cemented the Morgentaler legacy, didn't it?
It did. Because that bill failed, no other federal criminal law on abortion has ever been successfully passed since.
So the lasting result, the situation today,
is that Canada remains one of the very few countries globally with no specific criminal law restricting abortion.
Instead, abortion is regulated just like other medical procedures.
Under provincial healthcare laws and medical college guidelines, as an insured medical service.
The Morgentaler judgment fundamentally, and it seems permanently, took abortion out of the criminal code, shifted it from justice to healthcare.
Exactly.
And this unique Canadian situation, governed by constitutional rights interpretation rather than specific legislation, has made the Morgentaler case a really important global reference point.
Hugely influential, especially when constitutional courts in other countries grapple with similar issues.
How so? How does it compare to, say, the U.S. approach?
Well, the American system, before Dobbs overturned Roe v. Wade, relied heavily on the trimester framework from Roe. That was a very specific, almost legislative-like policy framework created by the court.
Right. First trimester, second, third, different rules.
The Canadian Morgentaler judgment, however, focused entirely on the process of state interference, on how the law itself violated bodily integrity and fundamental justice under Section 7.
So it's more about the principles of how the state can or cannot act, rather than setting specific medical rules.
Precisely. This process-based fundamental justice analysis is really appealing internationally because it lets courts sidestep having to define precisely when life begins, a huge moral and philosophical question.
Which courts are often reluctant to do.
Understandably. Instead, they can focus on the constitutional limits of government power over the individual.
So Morgentaler gets studied internationally and debates about basically three key things.
Bodily autonomy. Establishing that core right to make decisions about your own body free from state coercion.
Reproductive rights. Defining the scope of protection for people making those choices.
The broader question of the limits of state control over private life.
It provides this powerful example of using a charter or a Bill of Rights to draw boundaries around government intrusion into really intimate parts of our lives.
Definitely. And for Dr. Henry Morgentaler himself, the man who went through arrests, trials, jail, the judgment was just total vindication. Historic.
He won the ultimate legal fight against the state. His clinic stayed open.
And his decades of principled, relentless opposition became this undeniable, pivotal part of Canadian legal and social history.
It really crystallizes it for you, the listener. Very few people can say their personal defiance directly led to a massive constitutional shift that changed the legal protections for millions.
Morgentaler is absolutely one of them.
Okay, let's wrap up. We've completed our deep dive into R.V. Morgentaler. It's this incredible story of one man's sustained defiance against a system he saw as deeply unjust.
And how he leveraged the power of Section 7 of the Canadian Charter.
To ultimately guarantee constitutional security of the person and bodily autonomy for Canadian women. And the final, maybe most powerful takeaway for you is this. Morgentaler reminds us that constitutional progress isn't always neat or tidy or politically convenient. It often doesn't come from legislative consensus in Parliament, does it? Especially on deeply divisive moral issues.
No, sometimes it has to be forced in a courtroom, where judges are obligated to weigh existing criminal laws against the most fundamental, protected freedoms in the Charter.
The Charter, in this case, really became the ultimate tool, defining and enforcing individual liberty against government overreach.
An incredible piece of legal architecture, as you said.
It truly is. So we'll leave you with this provocative thought to explore, building directly on that constitutional reasoning from 1988.
Okay.
If the abortion law was struck down based on violating security of the person, which Dixon defines so broadly as profound interference with her body, and forcing her to ignore her own priorities and aspirations, what other kinds of mandatory procedures, or maybe restrictions on medical access, or even other forms of state control over highly personal lifestyle or healthcare decisions? What else might qualify today as that kind of profound interference?
Interesting question.
What aspects of modern life might still need to be tested constitutionally, using that expansive Section 7 reasoning that Morgentaler established?
Yeah, where else might that profound interference standard apply?
Something for you to mull over. Perhaps investigate further as you go about your day.